Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in my today's class I am going to continue from my last class where exactly I have left. Yes, we were discussing chapter 6 of Evidence Act, which is all about the exclusion of oral evidence by documentary evidence covered between section 91 to 100, and in my last class we have already understood all about section 91. And there I have repeatedly told that we cannot separate section 91 and 92. We have to read them together. Why is that? I am going to explain all that in this presentation while explaining section 92 along with a beautiful chart, lot of illustrations and case laws. Not wasting your time, let's get into the first slide. Section 92 discusses about exclusion of evidence of oral agreement. Now, looking at the title, you might be feeling that this is almost the repetition of section 91, and if you are feeling so, you are right, because section 92 speaks most of the time the major part of section 91 itself, but then it moves to 6 important exceptions where oral agreement can be given. And under section 91, it is very clearly spelled out that whatever exceptions are given under section 92 are valid. Now, looking at the legal language, it says when the terms of any such, when I say any such, whatever is being discussed under section 91, any such contract or grant or any other disposition of property or any matter. Now, while discussing under section 91, this any matter was not there in the proviso, but then it is added in explanation that any other matter other than the contract, grant or any other disposition of property is also not an automatic exclusion. That is very clearly spelled out under section 91, and under section 92 it is made further clear by adding contract, grant, any other disposition of property and any other matter. Now, if they have reduced to the form of document which is required by law. Now, we have already discussed at least 2 sections, that is section 54 from Transfer of Property Act and section 17 of the Registration Act. There it is very clearly told that they need to be under document. Now, these documents need to be proved by documents only. The oral evidence or agreement will not be considered. Now, such documents, that is contract, grant, any other disposition of property or any matter, is being proved as per section 91 already. In that case, the documents themselves are the proof and no evidence of any oral statement can be admitted. Now, the court cannot take any oral agreement as between the parties to any such instrument or their representatives in interest for the purpose of contradicting, varying, adding to or subtracting from its terms. That's all section 92 says. But then it gives 6 very important exceptions where oral agreement can be considered. What are these 6 exceptions? The first one is invalid document. If the document itself is invalid, in that case, oral statement or evidence can be considered. Now, what is an invalid document? If the document is made by force or under mistake of law or without consideration or for illegal purpose, etc. I am going to explain this in my next slide. In that case, the document itself is invalid, and to prove that, oral agreement or evidence can be considered. That is the first exception. The second one, there are few oral agreements available which is not inconsistent with the documented terms. In that case, oral agreement can be considered by the court. The third one, when an oral agreement is attached to the conditions precedent, in that case also oral agreement is considered as valid. And the fourth one, if there are any subsequent oral agreements, and if law allows that, in that case, that is also an exception where oral agreement or evidence can be taken. The fifth one, when it is related to the usage or customs, in that case oral agreement can be considered. When I say this, if it is explaining that the usage or custom of a particular place or time is that, and that is the meaning of that particular document, in that case to explain that, oral evidence can be considered. And the last one, if it is related to language of a document, there is a particular term and the term need to be explained in front of the court, to explain that the oral evidence or oral agreement can be considered. These are the 6 exceptions available under section 92. Let us go through them in little detail in my next 2 slides. This is section 92, the Bare Act provision. You can read through. I am directly getting into the provisions or the exceptions. The first one is about invalidity of any document, which can happen because of fraud, intimidation, illegal purpose, or incapacity, or failure in consideration, mistake of fact, or mistake of law. If the document is done by any of these, in that case that is an invalid document, and the same can be proved by oral statement or oral agreement. That is the first exception. The second one, there are certain number of oral agreements available which is not inconsistent with the document, and such oral agreements are allowed by law. In that case, that is also an exception where oral agreements are valid. The third one is related to the precedent conditions. Now what is this? Imagine A and B are there. A is the owner of a particular house and B is the tenant. Now they are coming to a contract that B is going to occupy the home on 1st January 2020. But on the said day, the earlier tenant has not moved out of the home, and that is why B couldn't occupy the home. In that case, there is no question of paying rent to A arises till B has occupied the home. Here, the first condition or the precedent condition for B to start paying the rent is he has to get the occupy for that particular home. Till then, there will not be any question of paying rent, which is what precedent condition. That can be proved by oral evidence. The fourth exception is the other part. Under third exception, we have discussed about the precedent condition, whereas here we are discussing about subsequent oral agreements. However, the same needs to be allowed by law. In that case only we can consider this particular exception. Then comes the fifth one, where the question is related to any usage or custom. Here what happens? The same can be orally explained if it is related to usage or customs, and the proviso 6 or the exception 6 is the continuation where the question is related to language of a document. Here also oral agreement or oral evidence can be considered to explain the language that the parties have used in the document. These are the 6 exceptions, and with that I am taking you to illustrations, and then let's move to the case laws. In the first illustration, there is shipment of some goods by ship, and if someone says there was an oral agreement between the parties, the same cannot be proved because for such big transactions there should be written documents. That is about illustration 1. In the second illustration, there is already in the document that the party has agreed to make the payment on 1st March 1873, and here the parties cannot say that oral agreement is there to make the payment by 31st March because it is not inconsistent with the documentary part. Only when it is inconsistent with the document part it is okay, but if it is inconsistent, in that case the same will not be considered. That is what we need to remember. The third illustration is related to selling of a property. Now here if someone says that this property is sold and a particular part after the property is not shown in the map, however the same is always considered as the part of this particular property. If someone says that cannot be proved because the property needs to be in the map very clearly, there we cannot assume anything or take any kind of oral evidence. The fourth and fifth illustrations are discussing about misrepresentation and mistake respectively, and the contracts which are made by misrepresentation or mistake or fraud or any force etc., the same is not valid and the same can be proved by oral agreement or oral evidence. That is what we need to remember. Illustration F again discusses about mistake. I will not get into that. Illustration G is about selling of horse where the amount is very clearly mentioned but the soundness of horse mind is not mentioned, but the same can be orally proved in the court. Illustration H is about A hiring a particular lodge from Mr. B. Here the same is required to be documented as per the law, but if it is not documented, in that case A cannot prove anything which is not available in the document. That is what we need to understand. Last two illustrations where A applies to B for a debt due to A by sending a receipt for the money and B keeps the receipt and does not send the money. Here A can sue for the amount and prove this. And lastly, A and B make a contract in writing to take effect upon the happening of a certain contingency, and the writing is left with B who sues A upon it at later stage, and A may show the circumstances under which it was delivered. That is possible. This is all about the illustrations. Now let's move to the case clause. Coming to the case clause, the first case law that I am discussing here is S. Saktivel versus M. Venugopal Pillai. This is a very important case law because here we are also understanding the term of parole evidence. What is parole evidence? It is an oral evidence or oral agreement. Now in this case law, it was very clearly held that if there is a document already available, in that case the terms whatever is been already available in the document, on that we cannot take any parole evidence which is inconsistent with the document terms. That is what very clearly held in this particular case law. That way when document is available, the document speaks for itself. Only the exceptions can be discussed. The document terms cannot be denied or rejected because of the oral statement. That is what we need to remember, except for if the question is related to the validity of document itself. That is one another important aspect. And coming to the case law name, if you see S. Saktivel by LRS, what does that mean? Yes, Saktivel is dead. Now his legal representatives are fighting the case. That is why the case law name is given as S. Saktivel, who is dead, and this case is fought by his legal representatives. That is one another aspect you can observe. The second case law, which is again very interesting, that is Parvinder Singh versus Renu Gautam, where it was discussed about the position of a stranger in a document. And in this particular case law, it was very clearly held that a stranger to the document is not bound by the terms of the document. That is a very important aspect we need to remember. The last case law, that is B.B. Lohar versus P.P. Goyal, it was held that inference can be drawn regarding proof of document by admission of parties, either oral or other evidence. Here the admission of parties is very important, and mostly if it is related to usage or custom or language etc., the inference of the parties can be taken as an admission, which is what held in this particular case law. Nishan, why are you bothering my students? Nishan, do you know how many tigers are there in India in the year 2020?
Yes, Papa. It's 2967.
You are right. In the year 2010, we just had 1706 tigers, and by 10 years, now we have 2967 tigers. We have to save tigers.
With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.